the bill to the House.
The question is that the motion be agreed to. I call the honourable member Andrew Little.
Thank you, Mr Speaker. Pleased to rise and speak on the criminal procedure legislation bill and to confirm the Labor Party's support for the bill. Sir, the project of overhauling our criminal procedure legislation started under the last Labor government. It was overdue and it was a welcome change. And so this legislation tidies up the bulk of the work done under the previous criminal procedure, or what is now the Criminal Procedure Act, due to take effect on 1 July this year. And I know, Mr Speaker, from getting around members of the profession over the last couple of months, there is a combined sense of both anxiety and also a palpable sense of thrill that the profession has about the coming into force of this legislation, because there were problems, major problems, with the administration of criminal justice in this country, and foremost amongst those were the delays being experienced, certainly at the District Court and also at the High Court level in many registries around the country. And the profession was very keen to see changes made that would enable cases to be brought on and justice to be administered as indeed it should be, in a timely fashion. As we all know, justice delayed is justice denied, or as it was quoted at one point last year in this House, sometimes justice denied is justice delayed. The logic of that proposition, of course, needs no further explanation and will get none from me. So, sir, we welcome the legislation. It was the right thing to do. And now the government, this government has discovered there are tidy-ups required. That might call into question, however, the speed with which even a piece of legislation that went through a very deliberate process can sometimes lead to flaws that have to be corrected. It was good that the implementation date for the legislation was there was a considerable lapse of time, so that it was 1 July this year, so there was time to review. There was time to review it, and I can think of other laws where it would be entirely appropriate. In fact, some legislation that had their first reading in the House only this afternoon could well do with a much more considered and deliberate time frame to make sure they get it right. I can think of the Family Court Proceedings Reform Bill that is presently working its way through. That should have been given ample more time to have it properly considered, rather than pushed through a great cause of anxiety to the profession, and a submission period that encompassed 4 or 5 or 6 weeks of a Christmas break and caused major problems for those who were showing their professional or offering their professional expertise and skill to assist the committee and this House. But, sir, that is beside the point. So, sir, we welcome, naturally, any changes that will improve the administration of criminal justice. There is another important principle in all this, which the Law Society, a point the Law Society made in their submission on this bill, this amending bill, this tidy-up bill, and that is that, to the best extent possible, criminal justice legislation, if indeed not all justice legislation, should be done in this House on a bipartisan or multi-partisan basis. Because that is, when we are talking about the administration of justice, when we are talking about potentially imposing criminal sanctions on people, depriving them of their liberty, that is a matter that the House should reach agreement on for the benefit of all our citizens. And so, sir, it is good that this legislation, as indeed the Criminal Procedure Act, as it was being processed through this House, has the support, by and large, of the whole House. That is the way it should be. The criminal justice system needs to be robust, and it requires the robust support of all parties in this House. So it was good to see, and I, of course, speak on this bill not having had the benefit of sitting on the Select Committee at the time it was going through. But I do see, sir, and the government is entitled to credit for listening to the submitters and the other parties on the Select Committee in processing this bill. And so changes were made. although it is largely a technical bill, changes were able to be negotiated and were indeed made. And a principal change that the Honourable Chester Borrows has adverted to in his presentation just now was the Henry VIII clause that would have allowed changes to primary legislation and references to the term crime in that legislation to be amended through order in council. Now that has gone under this bill. That is the correct thing to do. The term crime, whether it's in the Crimes Act or any other piece of legislation, is a sensitive term, a term of art in many respects, and if that term is to be changed in any legislation, then it should have the proper oversight and scrutiny of this House. And that will be the case with this bill as it is reported back to the House from the committee. There are other amendments made to, Sir, the clarification of charging documents. We are no longer have informations laid now in the criminal justice system. We are to have charging documents. There is a waiving of fees, or the procedures and rules around the waiving of fees to access documents are clarified and made and improved, and that is a good thing. Sir, the administration of justice, criminal justice, is a crucial aspect to the principle of the rule of law, and it is our adherence to the rule of law as a principle and in practice that makes us a developed, modern, civilised nation. And that must underpin what we do in criminal justice and indeed in any justice legislation that we pass. But, Sir, I think it is timely to point out in this regard, in too many other cases, we have a government at the moment that is showing a willingness to ride roughshod over basic rights and principles. And that runs counter to adherence to the principle of the rule of law. And we have seen tonight, Sir, in other debates, exactly that risk being taken, that threat being imposed in the conduct, or at least in the debating and passage of other legislation. The rule of law is absolutely crucial. That is why we have now the World Justice Project, sponsored by the American Bar Association, now has a rule of law index for every country in the world. And New Zealand presently rates reasonably well in that rule of law index, but it is the actions of this House and of government agencies that will determine whether we maintain our high ranking in that register. And we don't want to compromise our position. Having a good standing and a good rating on the rule of law puts us in good stead internationally, not only as good international citizens of the world, but also for our commercial and trading partners to know that this is a place where they can reliably do business. And they must also know that when citizens of other states come here and they are subject to a criminal regime, that they know that that criminal regime will also be subject to the basic principles of the rule of law. But that is not what we've seen in other cases, in other situations. And only today and yesterday we've seen a Minister of Justice talking about, as a knee-jerk reaction, introducing now a new register of deported offenders. It's offenders, New Zealand citizens, deported back to New Zealand after committing offences in other countries, as a permanent record of their offending, and with no scope for them to put their evil past behind them and embark on a good future. We've seen the family court reforms launched on this House now had to be changed because of some of the failures to observe basic principles of the rule of law, the denial of the rights of counsel, particularly to children, which we know is a breach of our international obligations under international conventions. And so, Sir, the rule of law remains important. That's why this bill is one of those bills where now we see, when the House gets it right, we see that our standing and our place when it comes to measures of the rule of law is good and sits at a high level and is the right thing to do. So, Sir, on that basis, we're thankful for the government taking the time and effort to listen on this criminal justice legislation, and we support this legislation.
I call the honourable member Scott Simpson.
Thank you, Mr. Speaker. As Chairman of the Justice and Electoral Select Committee, it's a great pleasure to stand and